Yeah, right. Yeah, for it's branding that you just saw in the class. Yeah, I was wrong, but I'm like, what? Is not very used to this. All right. Court of Appeal Input District of the State of Florida is now set. Honorable Gary Wozniak, judge presiding. All persons having business before the court draw near give attention and you will be heard. God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome to this session of the Sixth District Court of Appeal. I'm Carrie Ann Wozniak and I have with me today Judge Petra Brownlee and Judge Rachel Kamoutzis. We have 3 cases on the docket today, and I want to remind everyone that we are recording and live streaming this session. We will go ahead and get started with the first case, which is 25-0832 Rudolph Johnson versus Ramon Fernandez Jr. and State of Florida.
May it please the court. I'm Tyrone King and I represent Mr. Johnson, the appellate in this case. We're here because Mr. Johnson was a victim of a shooting at the Corona Bar here in Orlando. A security guard shot Mr. Johnson in March of 2015 in the stomach while 3 individuals were holding Mr. Johnson. The shooter, Mr. Fernandez, let me back up. Mr. Johnson was hospitalized for about 18 days, incurred approximately $800,000 in medical bills, had multiple surgeries, and was arrested by law enforcement upon his release from the hospital. The state attorney's office then reviewed the video of the shooting and determined that Mr. Johnson should not have been arrested. He was the victim, and then issued a warrant for the arrest of Mr. Fernandez. They released Mr. Johnson and no info the charges against Mr. Johnson.
Mr. King, can I just interrupt and ask you because this strikes me as being somewhat unique, and it might not be in your, well, I think from the dearth of authority that we're able to find through Westlaw, right? That's probably apparent. Can I ask you, how do you envision, if you're to prevail, that this goes down, so to speak, at the trial court level? Like what level of participation will your client as the victim have?
So there are several scenarios. First, we weren't given an opportunity to intervene. So obviously, Mr. Johnson has an interest in the outcome of just the stand your ground hearing, because he had filed a suit against Fernandez, and he also anticipated filing a suit against the Corona Bar that employed Fernandez. And so if immunity attaches to Fernandez, he's precluded from suing the Corona Bar and Fernandez.
But why under that Kumar case out of the Florida Supreme Court? I mean, that says it's of no moment whether he's ultimately convicted, right?
Correct. So we've got 2 opinions. You got Kumar and you got Fleming's that's mentioned in Kumar. Kumar basically stands for the proposition that, look, there has to be 2 separate hearings, evidentiary hearings on the immunity issue. There's going to be the stand your ground hearing in the criminal case, and if the civil defendants assert immunity, there's got to be a separate hearing in the civil arena. That's the only outcome in the Kumar case. The Fleming case then says there is no res judicata or collateral estoppel in the civil case, if no matter the outcome in the criminal case.
Yeah, because he's not a party.
Right. The issue that we have is with the order that was drafted by the trial court. The trial court said you're not allowed to intervene. And then on rehearing and a motion for clarification, Mr. Johnson asked that no matter the outcome, the order there, the ruling, the determination there has no moment in the civil case. So basically, if you're removing Mr. Johnson from the criminal stand your ground hearing, whatever you determine, can we have an order that says that outcome will not be utilized in the civil immunity hearing? So if the court over here in the criminal case says he's immune from prosecution, I can foresee a civil defense attorney taking that order and going to the civil arena and saying, this has already been decided. I know it's not res judicata, I know it's not collaterally estopped, but the court should consider the trial court's ruling in the criminal case. Well, the trial court said, no, I'm not precluding anyone from using the outcome here in the civil arena. And so that's the narrow issue that this court has to address.
So you just want it like prophylactically then?
Correct. If we're not allowed to, Mr. Johnson's not allowed to participate here, and the outcome is not res judicata, he's not collaterally estopped over here, there has to be a separate hearing. Why should they then be allowed to take the ruling and present it to a civil judge in the civil arena?
Can you expand on what you mean by participate? So your client wants to be a party, not just have standing to be a witness and whatever else the rights would be
Yes,
as a non-party, just as a victim under Marcy's law. So your client wants to be a party participating.
correct.
Is that only for the stand your ground part? Is that for the entire case? How does that work
That's it.
practically?
That's it, just for the stand your ground hearing. And let me tell you why. So there were multiple meetings with the state attorney's office in preparation for the stand your ground hearing. One of the defenses to the stand your ground hearing is that Fernandez was committing a felony before Mr. Johnson was shot. The video shows Mr. Fernandez striking Mr. Johnson in the head. So there's a wanding of Mr. Johnson, and Mr. Johnson turns around, and Fernandez on video takes the wand and smacks Mr. Johnson across the head, causing a laceration. In these meetings with the state attorney's office, we said, look, you need to call the doctors that treated this laceration to show that Fernandez committed an aggravated battery before the shooting. And therefore stand your ground is not available to him. Well, when we got to the hearing, the court stayed, the day of the hearing, the trial court stayed this stand your ground hearing because we had filed this appeal. But when the state walked in, they had no doctors, they had no medical records. They weren't going to present anything about the laceration and the aggravated battery, because that would shut the door to the stand your ground defense. Because he can't be committing a felony and then say he's standing his ground. And so the reason why we wanted to participate was because we were going to call those doctors to testify. We also retained a security expert that was going to testify that Fernandez had escalated the situation as opposed to de-escalating. The state was simply going to show the video and ask the court, make a ruling. And
So the
so,
state would participate as the state, and then your client would then participate in the same hearing,
Yeah.
bringing whatever evidence, and then the court would decide based on all of that. Would you have the same clear and convincing burden of proof?
in the criminal case, yes.
Okay, even though the statute, I believe, says the state has that burden?
Yes.
You would take that on too, okay.
Can you show us in Article 1, Section 16 of the Florida Constitution, Marzy's Law, right?
Yeah.
Can you show us what provision that you're coming under that would permit such participation by your client?
That was an issue in the trial, at the trial level, where the court seemed to think that Marcy's Law created this box that the victim was in, and the victim had no other rights other than what Marcy Law indicated. Well, if he had an interest in the outcome, obviously he can intervene, just like newspapers intervene, hospitals intervene for restitution. And
But
so,
they're not parties in those cases, right? That they just have standing in those cases.
right, and that's what we were asking for. We weren't asking to be under the V. We were saying we have an interest in the outcome of this limited issue. We would not be participating in the trial. But to your Honor's question, if you take a look at Section D, first it says the granting of these rights under Marcy's Law may not be construed to deny or impair any other rights possessed by the victim. So the victim in a criminal case has all the rights available to them that any other individual would have, such as the Miami Herald or any bank or hospital that was looking for subrogation in a case.
But counsel, under this logic, is there a limiting principle? Like you're saying we just wanted to participate in this limited proceeding, but under your argument, why should it stop there? Why wouldn't it continue forward into trial?
Because I don't think there's a recognized interest that Mr. Johnson would have in finding Mr. Fernandez guilty. Of course, every victim wants the assailant or the suspect to be found guilty, but I don't think that that is a right that rises to the level of interest that's recognized in the Union case that outlines intervention. So we've seen that in subrogation where, like I said, a hospital or a bank or whoever wants to recover monies from a suspect. We've seen it where the court wants to close proceedings to the public and the newspapers or television networks want to intervene just for the limited purpose of that motion dealing with the closure of the courtroom. So the newspapers or TV stations, they don't want to participate in the prosecution of the defendant. They want to participate in this limited issue of closing the courtroom. So they had a right under the Constitution to present news. My client has a right under the Constitution to have access to court. And what the civil issue, this immunity issue was doing was eliminating his access to court. Now, the Kumar case and the Fleming case says that can't be done in the criminal case. It won't be eliminated, but the outcome should not transition over to the civil case at all. And that's what we asked. If the trial court would have said in the motion for reconsideration, I agree, Mr. Johnson, the outcome here will not be utilized in any way in the civil proceeding, case closed.
What did he say? Does he
The
just not say, does he just say rehearing denied?
No, the trial court wrote, and this is a quote, consequently, the court finds the victim's request to issue an order stating that immunity will not be imputed in any way to adversely affect the victim in the pending civil proceedings and will have no bearing on the outcome of the civil proceedings would also be inappropriate as it clearly requests the court ignore the controlling statute. So the court looked at the trial court looked at the immunity statute and said, of course, the outcome here can be utilized over there. So both can't be true. Mr. Johnson, under the Kumar case and Fleming case, Mr. Johnson can't sit idly by and do nothing in the stand your ground hearing and then have that outcome affect him in the civil arena. Again, it won't be res judicata. There has to be two separate hearings, but the trial court is saying they could take my ruling and utilize it over in the civil arena.
Counselor, can I just ask a quick question about, do you see any issues of separation of powers? I know that wasn't really briefed in your brief, but any issues of separation of powers where a judge is essentially could compel the state to allow certain evidence into a proceeding? Do you see any separation of powers issues there?
I don't. For instance, at a restitution hearing, the court could allow, as I said, an insurance carrier or a hospital to intervene and come in and argue its interest in restitution payments from the suspect or the defendant. There's no separation of powers issue there because it's been done in the past. The court can allow when let's say the state is arguing closure of the courtroom because they want to keep the identity of a law enforcement officer from reaching the public. The media comes in and the court allows the media to come in and argue that the courtroom should stay open and
those are
present
just-
evidence on that issue.
Wouldn't you agree that those are just distinct in nature? Here, this is actual execution and management and prosecution of a case of which the state is responsible for, not. I mean, there's obviously collaboration and interaction with the judicial, the judges, but I just see those instances different in nature than what's happening here.
So there is no criminal
Component.
component
the-
of
yeah,
intervention.
proceeding.
So they've been utilizing the civil intervention rules and allowing non-parties to intervene and present evidence and argue before the court. Here, Marcy's law says that we've got, Mr. Johnson has an opportunity to be heard, and even in paragraph C, it says the victim, the retained attorney of the victim, may assert and seek enforcement of the rights and any other right afforded by the victim by law in any trial or appellate court. The newspapers, the hospitals, they're seeking to enforce their interests or protect their interests. And that's what Mr. Johnson was seeking to do, is to protect his interests. He would not be calling witnesses at trial. He would not be making a closing argument at trial.
But why not? I mean, what, to Judge Kamoutsas's point, if we're allowing him to put forth evidence to dispute the immunity from prosecution, we're allowing him to question witnesses at that preliminary hearing. He's going to submit evidence. I mean, I could see a world where it sort of usurps the whole role of the assistant state attorney at that point. I mean, what if they don't have any evidence, right? I've had instances sitting in felony where no evidence is presented to me. And if all of a sudden this third party starts presenting evidence, well, now they're sort of standing in the shoes of the state. Number one, is that permitted? And number two, what mechanism would prohibit that from extending through the trial and just saying, fine, he might not have been granted pretrial immunity, but we still think he's entitled, like the jury still thinks he was acting in self-defense and acquits him.
So self-defense, for instance, if Mr. Fernandez had walked in and his argument was, I was defending myself, not asserting a stand your ground immunity defense, Mr. Johnson would have sat in the pews and watched the trial. There is no right, I believe, for Mr. Johnson to prosecute Mr. Fernandez, and that's not what he's asking for. If Mr. Fernandez only wanted to argue to the jury, I was acting in self-defense, it would not trigger the interest that Mr. Johnson is trying to protect. If Mr. Fernandez never asserted the stand your ground defense, immunity would not have been an issue. Back when I practiced criminal law, we could argue self-defense. It didn't trigger immunity. This statute triggers immunity, and Mr. Fernandez specifically sought the protection under this statute. And so Mr. Johnson would not be arguing, and I don't believe has any right to argue for the prosecution of Mr. Fernandez. Mr. Fernandez triggered what Mr. Johnson is seeking to protect.
You're into your rebuttal time.
Thank you.
May it please the court. My name is Richard Palace. I represent the state. The state will be pursuant to our notice we filed earlier in this litigation, will be arguing the positions of both appellees here. This is something that can't come up on appeal, and we don't meet the cert standard here as well. In the event that this was considered a petition for writ of certiorari. But just to touch on the merits here real quick, Judge Kamoutsas, you mentioned about this being a separation of powers issue. And I think Florida Constitution does have something to say about that. Article 5, Section 17, I believe, while not briefed here, talks about the duties of the state attorney. And if I recall the text correctly here, among other, it's the state attorney shall be the prosecuting officer of the trial courts. The state attorney shall appoint such assistant state attorneys as may be authorized by law, among other powers there. Fact of the matter is that our stand your ground statute, specifically subsection 4 of 776-032, talks about that the clear and convincing evidence burden shall be on the party seeking to overcome statutory immunity. So here, in order to step into this, the judge is asking the state attorney to allow the victim to become the party and thus become the party that is seeking to overcome this burden.
Can you help us understand jurisdiction a little bit? I understand principally
Yes.
your brief was concentrated on that, and rightly so. So do you agree, I mean, excuse me, at least in the civil context, motions to intervene, denials of motions to intervene are final as to the movement, right?
Yes, Your Honor.
Okay, why are we different here? I understand that there's a Florida rule of civil procedure that bears on intervention. There's nothing like that in the criminal law, but could we just look at it and say, well, it's a final order?
Well, no, Your Honor. I believe here we don't have a final order, specifically because we've pointed out, at least in our versions of Florida appellate procedure under 9140, what qualifies as final orders. And none of those have taken in a motion to intervene. Specifically, I believe the Warner case or Weiner case, that was the 1999 case out of the second DCA, specifically held that an order granting a motion to intervene was not an appeal, a final order for purposes of 9140.
That would stand to reason though, right? I mean, it's a denial of it, so they're going to go forth.
In terms of, is the motion to intervene final? Yes, Your Honor. The state certainly understands that there's no more judicial labor on the motion to intervene. But I believe that when we're looking at finality in the criminal case, and for specific Mr. Johnson here, our finality is on what his interest is. And him being denied a motion to intervene in the criminal case, seeking to protect his interest in the civil case, that is not final here, at least for purposes of what the state is looking for in terms of differentiating and distinguishing all of these civil cases from what we have here.
Doesn't 9140 also have appeals by the defendant, appeals by the state? It doesn't really contemplate appeals by anyone else.
Yes, Your Honor. It solely lists appeals by the defendant under subdivision B and appeals by the state under subdivision C. And the rules of appellate procedure go further into, I believe, Rule 9143, specifying what rights the victims do have in their appeals. And it cites that victims may file motions under, because that rule was, of course, created in order to work in part and parcel with Marcy's law here, subsection B under Article 1, Section 16. And importantly, if we look into the history of this particular, this newly enacted rule to go along with when Marcy's law was adjusted here in Florida, it states that this is not meant to confer party status. That's not in the text of the rule, of course, but it's interesting that the rule here is talking about filing motions, but not appearing as party status. And of course, I believe the exact phrasing of that, the rule committee note is this is not meant to confer party status upon the victim, at least for the purposes of appeals.
Under 776.032, and I think I misspoke earlier when I was talking about subpart 4, that the burden is on the state to overcome immunity in a criminal prosecution. It actually doesn't say state, it says the burden is on the party seeking to overcome the immunity. Who else would be the party in your position?
Your Honor, here I believe that that party would only be the state,
Okay.
solely because it states that it is only the criminal prosecution that subsection 4 apply.
Doesn't say state. Why does it say party? If you know.
It's in terms of the actual history of it, I don't have the notes for chapter 2017 when this was added in.
I'm just wondering who else it could be besides the state.
Here, certainly it leaves, if we only looked at that subsection alone and we ignored that it was a criminal prosecution, we could think that could be anyone here, but
Well, it starts with in a criminal prosecution.
yes, Your Honor. To me, that party could only be the state. It's, I mean, here we're, of course, just dealing with the clear and convincing evidence burden. The state must overcome the prima facie case of self-defense in order to go further in this prosecution. And then at that point, the state must prove its burden further beyond a reasonable doubt if it is raised again at trial. This, in terms of the state already talked about our separation of powers here, but just to go further, you know, talking about protecting Mr. Johnson's interest, that can only be done by him participating here as a party. I think that stating protecting one's interest is not the same as prosecuting this case. That is incorrect. I think that's mutually exclusive. In order to take part in this subsection 4, he has to participate as the party. And going off of party status, there's no standing in this case, at least. I know that the Kumar case and the LT case that the state relies upon, those are discussing that we have a difference between party status and our standing as a victim. Mr. Johnson certainly has standing as a victim, but he does not have standing to intervene.
So with that standing as a victim, then is it your position that we should consider this under cert and then it fails the initial jurisdictional prongs of the cert standard?
Both, it fails the initial jurisdictional prongs under the cert standard, but if this, understandably, LT did go further and actually considered the merits, I believe, under the departure of essential requirements of law, but I believe that was a little different, where that cert standard was the striking of certain notices and the victim's mother's rights being dialed back is what was alleged in their particular petition. Here, we're looking at something completely different that, again, we can't do irreparable harm solely because the interest is to protect the civil case. Kumar versus Patel is clear as day. I believe Mr. Johnson was discussing how this case, Fleming only discussed collateral estoppel in res judicata. That is also discussed in approval in Kumar versus Patel.
But in the LT case, the first district decides that the victims always have an interest, right?
Yeah,
Like,
Your Honor.
we agree that Marzy's law clearly sets forth a crime victim's legally cognizable interest.
Yes, Your Honor. That is clear as day in the text of the Constitution.
So
here.
then
They
does
have
he
an
even need to harp on this idea about the civil suit and what might be coming in that? Or, I mean, does he even need to allege that, or is it just sort of inherent in Marzy's law?
In Marcy's law, the interests, I believe, are what we are listed in the statute's exhaustive text here. And of course, the statute has its catch-all provisions under, I believe, subsection D. But here it is specifying their rights to be notified, their rights to confer with the state, their rights to be heard. Our level of participation can't become a magic pen to rewrite all of our laws here. I believe it was noted in LT, that argument came up in the trial court that to allow the participation as LT demanded, that envisioning would essentially rewrite the criminal justice system. And here, while there is an interest to be heard, to be conferred with, to be notified of everything, we have nothing to intervene. I think that yes, we have an interest under Marcy's law, but we don't have the interest that is being sought here. And just to go a little bit further from the fact that we're arguing that there's no irreparable harm, even if this court found that in having any interest whatsoever, civil suit or not, just to have standing as a victim and participate meaningfully in this case, Mr. Johnson has been allowed to file his motions. Nothing has been stricken from what I've seen. In fact, depositions have been rescheduled based on the limited record on appeal we have here. And just to say, if we did find that irreparable harm was satisfied, but we don't have a departure from the essential requirements of law. I think that to say res judicata and collateral estoppel do not apply under our Florida Supreme Court precedent, and yet we're still going to consider the case in the civil, a ruling in the criminal case in the civil case. That is collateral estoppel and res judicata here. It can't be ignored, certainly, whatever ruling is done in the criminal case, but the law is on Mr. Johnson's side. If let's say the defense was to move to dismiss the case under Marcy's law and said, not Marcy's law, the Stand Your Ground law. And instead of stating, we're going to meet our burden by a preponderance of the evidence, this court is bound, or this court should just consider the trial court's ruling, hypothetically, if Stand Your Ground immunity was granted. That he has a very clear-cut burden there, a very clear-cut procedural mechanism there to challenge that. And that would be to either appeal a final order granting a motion to dismiss, or it would be, it technically, when they're denied, I know Rule 9130 gives the defense interlocutory appeal jurisdiction for the civil proceedings. But other than that, there's no departure from the essential requirements of law here, because the essential requirements of law are what the Florida Supreme Court said. If this court has no other questions, I will rely on the briefs, and I ask that you affirm or dismiss this appeal, I should say.
So,
In Superior Fence, the fifth DCA indicated that an order denying a motion to intervene is appealable as a matter of right by plenary appeal, because the order constitutes a final determination of the proceedings as to the parties seeking to intervene. The parties seeking to intervene, this is a small p party, not a large p party. The state in the prosecution is a large p party. The defendant, Mr. Fernandez, is a large p party. Mr. Johnson is a small p party. He is someone who has an interest in the outcome of a certain issue. So for instance, the newspapers, the TV stations, we would not have any opinions from any district court of appeal or the Supreme Court of Florida if appeals were decided in criminal matters the way that the state wishes to argue. In other words, we wouldn't have newspaper cases discussing the First Amendment because they were not large P parties. They weren't the state and they weren't the defendant, and therefore they did not have any right to appeal. No, they have a right to appeal because they were seeking intervention. Intervention was granted. There was a ruling, and either they liked it or didn't like it, and then they appealed that issue, and we have appellate court opinions. So to say that if someone seeks to intervene, a party, small p party, seeks to intervene in a criminal matter, the outcome of that intervention can never be appealed until the end of the case, and the only parties that can appeal are the state and the defense. We would have no opinions to review. But we do have opinions because under Superior Fence, small p parties, if they are not allowed to intervene, their interests aren't being protected, they have recourse, and that is to file an appeal. They don't have to file a writ of cert. There was nothing else Mr. Johnson could do other than to file this appeal. He could not, even where I believe someone is aggrieved in this manner and they file a writ, it's been reviewed as simply an appeal. We would ask that the court not dismiss it, that there is jurisdiction. And I have 32 seconds if there are any other questions.
Does it matter to you if we consider it on, I mean, I think jurisdiction is paramount, don't get me wrong here. But do you think that a petition for, if we considered it under certiorari review, that would like foreclose your claim?
That wasn't briefed, and so there wouldn't be any argument before the court to protect Mr. Johnson. Thank you.
thank you, counsel. Are you okay? Okay, we're gonna move on to the next case. I'll give everyone a chance to switch out. Okay, the next case is 23-2972, Weisner Desmerit versus State of Florida. We ready to proceed?
Yes, sir.
Okay, and let me get this switched out. Okay, 20 minutes. How much time would you like for rebuttal?
3 minutes, Your Honor.
3 minutes, okay. All right, we are all set to begin when you're ready.
Good morning, Your Honor. Good morning, court. May it please the court. My name is Jaime Lapidus on behalf of the appellant, Weisner Desmerit. We are here, Your Honor, because Mr. Desmerit was allowed to represent himself in a capital case, the first case he had ever gone to trial or experienced a trial, and in a situation in which a death certified attorney is informing the trial court, he is not on the same planet as us. That might be a correct line for the cover of a comic book, but when regards to a death certified attorney's representations regarding the incompetency of an individual representing themselves, it is a stark departure from the requirements that the court must now, as sufficient doubts have been raised as the individual's competency, the court must at that point halt the proceedings and have another evaluation. This is an individual, and the court was well aware of this because it took judicial notice of Mr. Desmarais' entire mental health history. Mr. Desmarais has spent his entire life in mental health treatment. He was treated for low IQ when he was in education and as a child. You don't suddenly recover your IQ as you grow older. He was treated for significant mental defects throughout his entire life and within the judicial system. In fact, the court was well aware that every case in that county and others that Mr. Desmarais had gone through the judicial system, not only was he found incompetent, he was hospitalized.
In this
Fortunately-
case, he was found competent by multiple experts, right? Right before trial.
Yes, competency was raised twice. He was evaluated. He was found incompetent by one doctor and found competent by others in 2 different proceedings. However, if we're going by the numbers, prior to this case, 6 different doctors had found him incompetent in several felony cases that were all resulting in him being adjudicated incompetent and hospitalized.
Those are
Yeah.
separate proceedings, right?
Correct, but when the court takes judicial notice of this, this is relevant to whether the court, because when the court must consider whether there's a competency issue at heart, every one of these circumstances is relevant. It's not just the competency evaluations that occurred in the case, but rather the entirety of his entire mental health history.
But his mental health at the time, because mental health can come and go, right? That's why we care about the staleness of the evaluations and all of that. So those, I mean, I understand that from like a historical perspective, that might be relevant and perhaps the doctors might opine on that and take it into consideration in the present evaluations. But the prior evaluations that preceded this case wouldn't be properly before the court, right? I mean, those determinations of incompetency, the way that it sort of comes and goes wouldn't be appropriate, right?
Well, I think Your Honor used 2 very appropriate words to describe the evaluations in this case, staleness and historical.
But did you argue staleness in your brief?
I did use that, I believe I used that exact term staleness, I believe it was a heading in my reply brief, Your Honor, because in this case, the evaluations the court relied on happened 2 years before trial. The evaluations for his ability to waive counsel happened around a little over 6 months prior to the proceeding to trial. So in regards to
Is found competent like 5 months before trial, right? by-
6 months, Your Honor, 6 months to waive counsel. It wasn't.
September of 20, the end of September of 20?
Yes. And in fact, that particular evaluation was limited in scope strictly to whether he had the capacity to waive counsel. And of note, in that evaluation, which occurred 6 months before trial, that doctor says he's not making any delusional statements about his defense or manifesting any form of mental illness at this point. Every evaluation actually cautioned the court to closely monitor him for decompensation. It was in every evaluation. This individual, and in regards to it's kind of the snake eating its tail, Your Honor. We cannot say we cannot consider the prior evaluations because the evaluations in this case, all reference the prior ones. They are part and parcel. The evaluations in this case reference those because every doctor who evaluated him was well aware of the fact that he had been hospitalized repeatedly. In fact, the tragedy of this case is that he had been released from a mental hospital the day before the incident. This was at its heart always a mental health case, always.
So what would you say, what are some things you can point to that were the change in circumstance? You know, he was found competent, he went to trial. Between the time he was found competent and trial, were there any changes in circumstances that the court was made aware of?
Yes, in the 2 years prior to the last competency evaluation, 6 months from the one to waive counsel, all those evaluations reference past tense in situations. He wasn't presently manifesting the mental illness in those evaluations. What we see what's happening throughout this trial, even at its inception, is that he's conversing with God in the courtroom. He's telling the court, I have higher sources. They are telling me right now, this prosecutor is an impersonator. This is a conspiracy to kill me. And he's not saying in regards to a defense. He is outlandishly describing a conspiracy to harvest his blood and organs. He's describing witnessing witches with brooms in the courtroom. He is actively and contemporaneously describing active hallucinations before the court, which leaves standby counsel at one point to literally stop the proceedings and tell the court, he is not on the same planet as us. And it's not that this is happening in a vacuum. As he's saying this, Mr. Desmarais is continuously interacting with the hallucinations in the courtroom. And now the case law is very clear where you have a circumstance, and again, all these factors are relevant, specifically the prior evaluations. We're talking about these pay presumptions, but the factors deemed relevant, and this is a Callaway v. State case, the first DCA 95, which these factors have always been the same factors, is the evidence of his irrational behavior, his demeanor at trial, any prior medical opinion on his competence to stand trial. In addition, and kingly in this case, the representations of defense counsel. So when you have a death certified attorney saying, hey, I'm death certified, that guy's not on the same planet as us, and he's actively hallucinating in front of the court. We're talking about a situation that would have taken an afternoon to have him evaluated, as opposed to coming back with significant concerns that a man who was, in our opinion, clearly incompetent, allowed to represent himself in a capital case and convicted of capital murder.
So counsel, on that though, weren't there multiple experts that also recognized he was engaging in this type of behavior, but found that he was malingering? So even those experts were recognizing, yeah, he's making these statements and bizarre comments, but we still recognize and believe that he's malingering and still find him competent. So that information was before the court at the time of trial.
Yes, I think that's half the story. And respectfully, I believe Appelli tells half the story of the accusation of malingering. The malingering representations in those evaluations came from his lack of cooperation. He didn't want to cooperate. It's not that he took malingering tests or things of that nature, but more so he just didn't want to be there or be evaluated. So what that turned into was, for the first time, after having been found incompetent in every case before this, having been hospitalized, he is not participating, and all of a sudden he's malingering. This is the first instance in which he has been accused of not having the mental defects that have defined his life. This is the first instance in which he's being accused of somehow being so sophisticated as to malinger and fake paranoid schizophrenia. And I know it wasn't part of the record in this case, but there is no irony that in every case before this one, he was found incompetent and hospitalized. And in the case directly after this, a month after he's sentenced, he is again found incompetent and diagnosed with paranoid schizophrenia.
It goes back to my initial question. What was the change in circumstance? If he had been behaving this way and found competent, nevertheless, what was the change in circumstance or change in behaviors that the court could say, this is different than what we have had going on before?
Well, Your Honor, with regards to behavior wasn't present. It was in the evaluations describing things in past tense, things that have happened to him in the past. That's why all the evaluations say he's not presently manifesting the illness. But the change in the circumstances is that he's clearly manifesting mental health illness throughout the trial. And I mean, it's not hard to imagine that someone with paranoid schizophrenia breaks down mentally when
But what was before the trial court was that he was not schizophrenic, like the most recent reports. And as I stated, these things, I mean, it goes to a point that you made, well, he has to be closely monitored, right? Because this could turn and all of a sudden he could be deemed incompetent. But everything that this trial judge, or not everything, but I think 3 reports, if I'm not mistaken, the latest reports that this trial judge has ordered to try to move this case forward for resolution for everyone said that he was not schizophrenic. Isn't that what that latest report stated? So I hear you saying paranoid schizophrenic, but this trial judge had several reports in front of him stating otherwise.
Well, actually, Your Honor, at the second motion to determine competency, Dr. Shadle's report said that, and this is on the record of pages 320 to 326, Dr. Shadle directly said that at the time of that evaluation, he was not evidencing hallucinations or delusions at the time of the evaluation. What we have during the trial is him actively conversing with figures of his imagination. I mean, the trial judge does not disagree that he should not have been representing himself. Throughout this record, at the very inception, the first time he says, I want to represent myself, is directly after the trial judge has handed an insanity defense motion, which references an expert to testify to significant brain defects and injuries. He decides to represent himself, and the court's exact words are, that cannot happen. You cannot represent yourself. Throughout every stage of this proceeding, he is telling the appellant, you don't understand. You need to understand, and you cannot understand. You aren't getting it. You need to focus. You can't focus. At no point does the trial judge throughout this trial say, hey, Mind you, it's never a good idea to represent yourself in a capital case. We can all agree on that. But when the trial judge is unambiguously saying this is a problem, when he's responding to standby counsel saying he's not on the same planet as us and saying, well, I'm well aware of his mental health history and the issues. I don't think it's a good idea he represents himself either, but he was found competent to do so. And that's 6 months prior, just competent to waive. If at that point, the judge is relying on a 6-month-old evaluation to continue to allow him to represent himself, and I know we're merging through different issues here, which this would be the higher standard as opposed to just the Drape competency standard. But when we go to this even higher standard, the court's response to to a capital attorney saying he's not on the same planet, saying, I know he's not mentally well, but he has a right to do this because 6 months ago, an evaluation said he wasn't presently delusional about his defense. The change of circumstances is that he's clearly delusional about his defense and hallucinating. Where if you're allowed to waive counsel because at that present point, you are not showing the evidence of their mental illness, but throughout the trial, there's not a single point in this trial he's not showing mental illness. Throughout this trial, there's not a single point in which he acts competently as an attorney. I believe Appelli points to a couple cause challenges. If you actually look at the record, he doesn't make a cause challenge. He didn't say, I'm raising cause on this juror. He's literally espousing about the fear in their eyes and how they all want to kill him. It's not eloquent. It's not even remotely close to practicing law, let alone having a functioning understanding of what's going on. His last words after he was sentenced are, I don't know what's happening. I have never known what's happened.
Yeah, but in the context of that trial, when he is sentenced, if you read that whole transcript in context, you're not being concerned about him being delusional or something like that isn't jumping off the page at you. I mean, he's engaging with the trial court and the trial court says, do you want to talk to Mr. Hollander again? We're about to impose sentence. And he's like, no, I don't need him. And I know he makes some concerning statement about him. But my point is he's engaging with the judge. So to say, I don't know what's going on here in a vacuum, I think that's more troubling than in the context of that entire sentencing proceeding.
Well, I think when you look at it in the context of the entire trial, he never understood what was happening. At no point does he understand jury selection. He doesn't understand opening statements. I wanted to quantify the amount of times the court interjected and spoke to him about mental health concerns. I actually lost count. I lost count during jury selection. There's not a single portion of this trial. And I understand that when it comes to the Sixth Amendment right to waive counsel, that for a lot of these factors, they've been kind of lowered in terms of looking at mental defect, but there's a reason why all these factors were present in prior decisions. And they're not bad law. He doesn't satisfy a single factor as to being allowed to represent himself at all. There's no point in this trial, not a single direct cross, not one part of this trial does he come across that he actually understands not only the process, but what's going on around him. And when you reference standby counsel and him interacting with the judge, responding to the judge doesn't mean he's not mentally ill. Most of the time he's responding to the judge, he's describing what's happening in his head that no one else has seen. He's saying that the prosecution is threatening him. He's saying the prosecution was stalking him. He's saying that standby counsel was contemporaneously choking him and saying things to him while everyone's looking at each other and saying, we're in the same room. That's not happening. It's not a question of, is he incompetent? The question is, it's a maybe. The standard before the court is, if he may be incompetent, the court must act. And when you know his history through and through, and again, this is the only case he was not forcibly hospitalized and found incompetent for, knowing that entire history, knowing and taking judicial notice of the fact that he has significant brain defects, showing brain injuries right before he allows him to represent himself. I mean, this is a situation where at no point was he competent, let alone was he competent to waive counsel and continue to waive counsel throughout these proceedings. All this, I think the court at this point has to weigh whether this trial court abuses its discretion in not simply having an afternoon taken in a capital murder trial to have him evaluated just to clear the confusion. Because again, the standard is not affirmatively, is he incompetent or not? Because all the case law says the judge can't make that determination. In fact, the case law is very clear that when defense counsel raises competency, the judge cannot question the appellant to substitute the evaluation. And that's exactly what happened here. You hear he's not in the same planet as us. The appellant is talking about a conspiracy to harvest his blood and organs for people with AIDS. The judge says, do you want to keep representing yourself? He says, yeah. Judge says, I think that's a bad idea. Let's bring the jury in. That is as far below the standard as imaginable, where the court now has a question of weighing whether it was an abuse of discretion, not simply to have him evaluated in the light of all the things happening to this trial, so in light of everything this court knew about this individual and his mental health history and defects, whether it was sufficient simply just to have him evaluated over the course of an afternoon, or whether we should sit and be comfortable with a record that demonstrates someone being, the trial court being informed that an individual is on a different planet currently while he's hallucinating, and that individual getting a life sentence as opposed to being represented by counsel or the proceedings occurring accordingly with competency. I mean, to me, it's the balance is obvious. We cannot sit comfortably knowing that an individual where there's genuine concern of his competency gets life in prison and is allowed to represent himself to his detriment, as opposed to the system actually working the way it's supposed to. But for the system being what it is, and all this case law saying where people previously found competent, I know the court was talking about the competency proceedings, but if we look at all this case law, Nowitzki in the Florida Supreme Court, reversible error in capital murder prosecution for refusal to order a second competency evaluation when his counsel requested it. That individual was found competent 3 months prior to trial, not 2 years, 3 months. And that was simply because the court rejected a plea offer and made irrational comments doing so. You have, I'm going to butcher this, Avi Sal Rosario v. State, 4th DCA in 2014. Abuse of discretion to allow for another competency evaluation, despite a prior finding of competency evaluation, where the defendant's attorney said he's not the same as he was. Here we have standby counsel saying in the 6 months since he's represented him, now we're in trial, he's not on the same planet as I am. You have Rodriguez v. State, Florida, the 3rd DCA in 2013. Standby counsel expresses concerns. The evaluation reports on record, the behavior of the defendant before the court during and after trial. And the most recent evaluation in that case was 11 months prior. We have cases after case where prior findings of competency don't control because things change, as the court said. People's mental health is an ebb and flow. And in this case, the flow went very south, and the judge just continued to just push through. And that was abuse of discretion. So we would ask that this court reverse. And I know I'm running into my time. I just did want to say one last note. The remedy that appellee repeatedly put in its brief regarding this court finding competency through reading the record is a non-existent remedy. There's a reason why no one can stand in and put themselves in those positions to determine competency, but for the situation where there's 2 evaluations and the judge just didn't simply put the order in. The only remedy here, if the court would agree with the appellant, is to reverse. Thank you.
Yeah, please the court, counsel. Wendy Buffington on behalf of the state appellee in this case. I would like to start with the final statement from Dr. Herzog's report, where he says certainly review of the medical record indicates that at times he is presented with what appears to be profound intellectual disability and psychiatric impairment. However, it's my professional opinion within reasonable psychological probability that these symptoms were malingered in an attempt to affect his legal situation. And this is the important part. Thus, while he may demonstrate these deficits, and that's in quotations, in the future, they would be viewed as volitional and not the result of mental disease, defect, or infirmity. And I believe as the trial played out, that was what we saw in this case. I would like to address the staleness issue regarding the reports. So we have the first finding of competency in December of 2019. That is based on the 5 reports. The 2 first reports being looking at intellectual disability, and that was Culver and Poirier. And Culver found no intellectual disability in that very detailed report, and Poirier, relying on prior reports, found there was intellectual disability. From there were the 3 reports on competency based on mental illness. All those doctors found competency at the time. So that was our first finding, which was actually 1 year after the initial request for competency. And now that competency is sustained over 3 years till our ultimate competency to waive counsel and represent himself. So we had the second competency reevaluation by Dr. Shadle based on defense counsel requesting that, we think there might be some incompetency here. Let's relook at this, and the court quickly did. And so what the record shows is not staleness, but continued competency over 3 years. Could it change? Sure, it could change, but we would have to have a change of circumstances. And based on these reports, which in 2019, 3 of them go into details about the bizarre allegations of persecution, people putting poison in his food, they're trying to hurt him. He sees angels, he sees black substances coming out of sprinklers, he sees shadows, he feels things running through his veins. Those kinds of allegations, which were again displayed at trial, and the state would disagree with the characterization of that Mr. Desmarais was demonstrating active hallucinations as opposed to reciting that he was experiencing hallucinations.
So Counselor, is it your position that this behavior that he was demonstrating in trial was just a continuation of the behavior that was previously observed by the prior experts that evaluated him?
Definitely, Your Honor. And who knew that best? The trial court that had been sitting on this case for over 3 years. He knew this behavior. He knew it from observing it himself during what ultimately became the Nelson Ferretta hearing, when Mr. Desmarais at that point made accusations against his counsel there that they were trying to put a needle in his arm, that they were on drugs, that they were sleeping in court. That was consistent with the kinds of allegations he later made at trial against standby counsel. And so this trial court knew all that and even makes that observation in the order denying the motion for arrest of judgment and motion for new trial, that the court further notes defendant frequently made bizarre comments during the pendency of this case. So a longer period than focal points of bizarre behavior. But upon being evaluated, experts would subsequently report back that he was competent to proceed. And then not every manifestation of mental illness renders a defendant incompetent to stand trial. As to Mr. Hollander's comments brought to the court's attention that Mr. Desmarais is alleging required further competency evaluation, those comments which were made were in the context as ruled on by the court, not of a new competency evaluation, but of let me represent Mr. Desmarais. He's not in any state to do this. Let me step in and take over the representation. What I think is
So he's not, I'm sorry to interrupt you, counsel, and I'm actually looking for the rule right now. It's kind of driving me crazy. But that moment when opposing counsel just alluded to this, that moment where the proceedings are supposed to stop because there's some question as to competency. And what opposing counsel has said is the moment that someone's questioning this, now we have to have that full hearing. You got to go get the evaluations. We're going to have that competency determination. Is there language in that rule? It's driving me crazy because I'm looking for it. Is there something that Mr. Hollander says that should have halted these proceedings? Because that's what opposing counsel has put forth. And if not, why is that? Or maybe that's not the exact language of the rule.
Reasonable grounds that defendant, the rule actually says is incompetent, but the case law says may be incompetent. So the reasonable grounds, if this was going to be not a prior competency finding, if this was the first time we have this conduct, we have Mr. Hollander raising this issue, yes, something should have happened. But because this was just more of the same, there was no need for the court to go further. And the issue on appeal is whether the court sua sponte should have done something about this at that point. And I think it is important to also note that counsel has represented that, it would have just been an afternoon recess. We could have had this all cleared up. After the motion for new trial is filed, which is before sentencing. So there's all this issue about competency and continue to represent himself. It's before sentencing happens, and yet there's not a request to have him evaluated. And if we're presuming all this conduct has showed him to be incompetent and we need a new evaluation, you just quietly let him go on to be sentenced while he's presumably incompetent. So based on these facts, with what the court knew, there had to be a change in circumstance, something different. And the Wall case talks about that this was more of the same behavior. So, and issues 1 and 2 basically rise or fall, on that issue of whether there is a change.
Counselor, how do you deal with the fact that periodically, and even opposing counsel had mentioned this, that even the judge kind of remarked or commented on his bizarre behavior? Against that landscape, why was it not an abuse of discretion for him to not order another competency evaluation?
Because he did know that it was more the same. He had all those reports in front of him. He additionally had all the prior reports that were discussed where the experts evaluating him in this case discounted those. They didn't rely on those. We had a different situation here. So there just wasn't a change. The court, of course, did not want Mr. Desmarais to represent himself. Nobody wanted him to represent himself except Mr. Desmarais. He wanted to represent himself. He had the right to represent himself as long as he was competent and was making a knowing and intelligent waiver of his right to counsel. And he was able to get evidence in front of that jury that no attorney could have because it wasn't factually or legally a proper defense. And as far as him not being able to function in the harmless errors section of issue 1 outlines very effective behavior on his part, where he had a present ability to consult with a lawyer over the competency standard. He sought to remove anyone from the jury with law enforcement connections. The court granted 2 of his cause challenges over the state's objection. He questioned Lieutenant Tarman on the threats that were made against him by the occupants of the car that drove up and ran over the phone. He asked Seaman how he knew the missing gun was Officer Jobber Miller's police-issued firearm. He reviewed his discovery and questioned witnesses about his fingerprints not being on the gun and suggested Taylor, one of the occupants of the Camaro, that it was his DNA that was on the gun because there was 3 DNAs on the gun. He asked the medical examiner whether the brain surgery, as opposed to the gunshot, might have been the cause of death. He asked about substances in the blood. He showed a very clear awareness of what was going on. He knew the facts of his case. He spun them in a certain direction and he pursued his defense. Ultimately, the court found perhaps he didn't do a good job, but that's not a reason to say that he was incompetent. I disagree with the judge on that. It looks like he did a good job here. He was able to generate question from the jury about the authority of the officer to pursue Mr. Desmarais, and he also got a life recommendation, which was always going to be the only best option for him on these facts with the evidence against him. So if the panel has no further questions, I'll ask you to affirm. Thank you very much.
It's Rule 3.210. And the case.
I found it. Thank you. But she brings up a good point. I mean, you kind of, hooked me there for a minute, but that wasn't raised on appeal, right? The issue on appeal is whether the trial judge should have sua sponte stop this and order these competency proceedings, not whether something Mr. Hollander said should have, led to a competency hearing. So
I disagree, Your Honor. It's their contention that we didn't raise, they disagree that Mr. Hollander raised competency. We have argued throughout our briefs that Mr. Hollander absolutely raised competency to the extent where he told the court that Mr. Desmarais is not on the same planet as us.
I'm not saying he didn't raise
Yeah.
competency. I'm saying the argument that the proceedings should have halted, something different should have taken place based on the rule and counsel making the argument regarding competency.
Yeah, I'll read directly from my brief.
Okay.
Representations of defense counsel are factors to be given special consideration. See Albisario v. State. When information offered by defense counsel is sufficient in and of itself to raise reasonable grounds to believe that the defendant may be incompetent, a trial court cannot substitute the required hearing under Rule 3.210 by questioning a defendant to determine if reasonable grounds exist. That's from Brockman v. State, a second VCA case in 2003. The rule is very clear. They just invented new law saying that if it's not the first time, they don't have to do that. Every case I cite in my brief was not the first time. In fact, every case I cite in my brief involved individuals previously found competent where there was an abuse of discretion that despite counsel raising issues, the trial judge did not act. The first time thing is not law. What is law is when someone says this individual is not right and the court knows there's a history of mental health issues, the trial court cannot discount all that to substitute itself in for the competency proceedings. They actually have to do what they need to do under the rule 3.1 or 3.210. And I know that appellee actually referenced, the ability to talk to a lawyer, things of that nature. I would challenge this court to find anywhere in this record where any factor for competency was satisfied in this record. He never had the ability to talk to his attorney. He never had the ability to understand the proceedings. The record is replete with circumstances where under every factor for competency, under Drape, he fails. And then when you raise that standard to the competency to represent yourself, he fails even harder in that regard. So we would ask again that this court reverse and remand so that proper competency can occur and this case can proceed without an incompetent individual representing himself in a capital case. Thank you.
Thank you, counsel. We will take a quick break and be in recess, and then we will go to the third case.
All right.
Okay, we'll now hear argument on our last case, 24-1464, Public Supermarkets, Inc. versus the Charter Oak Fire Insurance Company et al.
Good morning. May it please the court. My name is Steve Sen, counsel for Public Supermarkets. If I may request 5 minutes for rebuttal, please.
Yes, and you may begin.
Publix appeals the circuit court's dismissal with prejudice of its claims for insurance coverage, which should not have been dismissed at all, let alone dismissed with prejudice, because there are at least 2 separate and independently adequate grounds for coverage under the policy terms. For one, Publix is covered by an insured contract coverage provided in the policies because Publix is a party to an insured contract with Tri-County Sweeping, who is the named insured under the relevant policies. There's 2 policies here. There's the base policy and an umbrella policy, but they're alleged as being basically the same in terms of their terms. Second, Publix was provided a certificate of insurance, which states that Publix is included as an insured under the policy with respect to general liability as required by written contract. Now, this is an appeal from dismissal with prejudice for failure to state a claim. And so we have a relatively slim record. About half of the record is the initial complaint. And then the relevant record here kicks in around 220 or so. And it's basically the complaint and the exhibits there too, which include a copy of the policy. And it includes a copy of the contract between Publix and Tri-County, which includes a indemnification provision.
Counsel, how is the dismissal with prejudice issue preserved for appeal?
Well, it's preserved for 2 reasons. One, it's preserved because we oppose dismissal at all. And so if the case should not have been dismissed at all, then the dismissal with prejudice was clearly error. Second, the issue on dismissal with prejudice comes down to whether the court was able to find that there was no basis for any amendment that would allow a claim to be stated.
But opposing counsel asked at the end of the hearing if it was going to be with prejudice or without. The court said with prejudice. There was no objection to that, no further argument made by Publix's counsel, no motion for rehearing filed. So I'm kind of stuck there with preservation.
Well, clearly the objection to dismissal at all was preserved. We vigorously opposed it, and I was planning on spending most of my time today arguing that the dismissal at all was erroneous. And so that should moot out that question altogether. To the extent the court is interested in it, we cite various cases which seem to be somewhat unclear on whether the additional findings and additional levels of preservation that have been argued by the appellant are necessary in this standpoint. Rather, the bulk of the case law that we have cited appears to say that the judge should not do this unless the judge can find that there is no basis for an amendment that would sanctify. In most of those cases, there is no indication that a motion for rehearing was filed or any kind of argument was made. Here, it was stated on the record at the hearing that, and this is only with respect to the second issue on appeal, which is whether the certificate of insurance is adequate or not. And to the extent that there was any question as to whether it was issued with due authority, then that question could be resolved by additional pleading. But on its face, the certificate of insurance says that it was signed by an authorized representative. All caps.
Okay, going back to the preservation issue, if we find that the with prejudice issue was not preserved, where are we?
Then I think you need to decide whether the court was correct in finding that the pleadings that were before the court were adequate to state a claim.
So whether dismissal was proper at all, with prejudice or without prejudice.
Correct. And it was erroneous for 2 reasons. First of all, this is a insured contract. There is insured contract coverage.
Did you ever, is there a moment where Publix ever points the trial court to the insured contract coverage language in the policy? I see several references to the Ring Power case. and the arguments surrounding that, and peppered throughout those arguments are the term insured contract coverage. Did you ever show the trial judge in the lengthy policy what provision you were talking about?
I'm not sure whether it was quoted in the memorandum, but there was a memorandum that was filed in opposition to the motion to dismiss. That memorandum is in the record. That memorandum made the exact same arguments that I'm prepared to make here today, which is that there's coverage for two reasons. One, because there's insured contract coverage. And the
Yeah, but
other-
if you just say to me, hey, lady, there's insured contract coverage. I'm like, okay, there's insured contract coverage. And then you move on, or you're citing Ring Power, and I read the holding of Ring Power. Is there a moment where you take your policy and you show the trial court, here is the language, here's how it lines up with Ring Power, here's why we have insured contract coverage, rather than just asserting that that coverage exists?
Well, the policy was attached to the complaint.
So does the trial judge just read that whole
It does not
policy?
seem to be blocked with the memorandum itself, but it is cited in the
Complaint?
in the memorandum. Well, it's attached to the complaint, and then plaintiff's response to travelers with a motion to dismiss says that plaintiff also qualifies as an additional insured, cites to the amended complaint, the services agreement, says that the indemnity promise in the services agreement required Tri County to indemnify. Then it goes from there to say that the indemnity language in the services agreement constitutes an insured contract.
And then does it cite, that's the only relevant language.
Well, it quotes to the language from Ring Power, which is the same language which is in the policy here.
Do you tell the trial court it's the same language in the policy here, so that trial court?
I think and I can't cite the page of the hearing, but the argument was made that it's an insured contract. Ring Power was cited for that. The policy was attached to the complaint. And that
Does the complaint show the trial judge in any way what provision of the policy you're relying on?
it is
like,
not
do you-
block quoted in a memorandum.
I don't need it block quoted necessarily,
Yeah.
but like, is there a paren, exhibit A, page 13, paragraph 12, or whatever it is?
It says, here's what it says. Given that the indemnity language in the services agreement is purely identical to the indemnity language of the Ring Power, public qualifies as an additional insured by virtue of its insured contract right now. So the argument was made that this is the same kind of coverage as was involved in this other case. The same language appears in the policy. The policy is an exhibit to the complaint. It's deemed to be part of the complaint for all purposes on a pleading motion.
But it's talking about the indemnity language in the agreement. That's the agreement between Tri-County and Publix,
Not the
correct?
policy.
Constituted an insured contract, but we don't know what insured contract means. I mean, we know now because you did cite the provision and block quoted in the initial brief, but to my view, it was not, or my review showed that it was not in particular cited in the trial court. And so if I'm the trial court and I'm handed this insurance policy, that's, the part that I have on the general liability coverage is over 30-something pages, very small print. I mean, is that enough?
Well, there was a hearing transcript where the argument was made that it was part of the, that it was an insured policy provision. And we think that should be adequate for the court to consider whether the policy says what we said it says, which is that this is an insured contract and therefore it should be covered by the policy.
So insured contracts, if this language does apply, it means that Publix can come in as an additional insured. It doesn't just mean, okay, that contract between Tri-County and Publix is covered by this. So if Tri-County gets sued, then the insurer is going to cover Tri-County for anything that it's liable for. You're saying that no, that means that this insurance contract, I'm holding the insurance contract, it makes Publix an additional insurer.
Depends on what you mean by additional assured. Appellate courts are generalist courts. When general people talk about additional people being covered by a policy, it may well be perfectly understandable to refer to them as an additional insured. In the world of insurance, that can be a specific term which refers to additional insured endorsements. And there has been some confusion in the arguments over whether that is what we argued. In fact, in the Liberty case, The court uses that language, not capitalized additional insured, but additional insured because they were an additional insured because of the insured contract thing. But a lot of the cases that are being cited by the insurance companies here involve actual additional insured endorsements, which is a separate kind of policy language that we do not rely on here. We did not argue here. And on the insured contract provision and the preservation issue, there was no argument that this was not an insured contract and there wasn't an insured contract provision within the policy. The argument was based on these additional insured cases dealing with additional insured endorsements, which are not involved here, that there should not be coverage based on case law, which generally holds that the language of an additional insured endorsement generally requires there to be at least a claim for vicarious liability. And that's where a lot of the cases come down on in try to talk about what that means in different situations. And the vicarious liability issue doesn't apply here because we're not relying on that kind of policy provision. And even if it did rely here, there was a vicarious liability claim against Publix. So because there was no argument below that there's nothing in this policy that provides for an insured contract, there was really no need. The whole point of the argument was to clarify for the court that we are not relying on an additional insured kind of argument, which is what their motion to dismiss raised. We are relying on an insured contract provision, and we are relying on the certificate of insurance. And the case law we have cited indicates that both of those are separate and independently adequate grounds for providing insurance. Just the policy language that is relevant here begins with the provision at page 335 of the record. We will pay those sums that the insured becomes legally obligated to pay as damages because of bodily injury to which this insurance applies. There's later an exception to that, and the exception excludes insurance for bodily injury or property damage for which the insured is obligated to pay damages by reason of assuming liability in a contract or agreement. That's in page 336 and 362 of the record. But within that exclusion, there is an exception which says that it does not apply to liability for damages assumed in a contract or agreement that is a, quote, insured contract, provided that the bodily injury or property damage occurs subsequent to the execution of the contract or agreement. So the definition of insured contract is at 352, and it's defined as, among other things, that part of any contract or agreement pertaining to your business under which you assume the tort liability of another party to pay for bodily injury to a third person or organization. So the policy language and the fact that there is an insured contract with an indemnification agreement together leads to the conclusion that there is coverage under the insured contract coverage of this policy. And that's exactly what the 11th Circuit ruled, looking at essentially identical policy language in the Ring Power case. And realize that's not binding here, but it is persuasive. And it's persuasive particularly so because it's simply a straightforward application of the policy language to the claims. Straightforward application of there is coverage for an insured contract. There's a definition of an insured contract. Here's the contract. It has an indemnification provision in it. Therefore, there is coverage under the insured contract provision. The argument has not been waiver. The argument has not been to try to distinguish Ring Power. Rather, the argument consistently in the trial court and here has been that Ring Power was wrongly decided by the 11th Circuit. We don't think it was. It is consistent with Florida law. It is consistent with other cases that are cited within the opinion. It's consistent with a recent decision by the Federal District Court in Southern Owners Insurance Company. And we find no Florida case law, either federal courts applying Florida case law or Florida state courts that have suggested that Ring Power was wrongly decided or coming out to the opposite. That by itself should require dismissal because there is coverage on this underlying proceeding. But there is a second and independently adequate basis for coverage, which is the certificate of insurance, naming Publix as insured under this policy. It's in the record at page 400. And it states on its face that it has been signed by an authorized representative in all caps, which for purposes of pleading sufficiency should be adequate to allege that it was issued by a representative with the necessary authority to provide the certification. And the certificate of insurance identifies the specific insurance policies covering Tri-County and states that Public Supermarkets, Inc. are included as additional insured with respects to general liability as required by written contract. The insurance companies were able to persuade the trial court that caveats and disclaimers on the face of this document meant that it could not be relied upon to provide coverage. But Florida statutory law and case law is to the contrary. The key statute here, Florida statute section 627.4023, provides that a certificate of insurance is actually part of a policy. It's the definition of what an insurance policy is and includes any certificates. That apparently is not a common statute. Florida has it. Many states don't. So to the extent that some courts in other states have placed less credence on a certificate of insurance, it's because their law may be different. It's part of the policy. This policy identifies Publix as an insured. It's not some separate floating document that may or may not be relevant evidence. It's part of the policy.
How do we know in the certificate of liability insurance who the authorized representative, whoever signed this, who were they an authorized representative of? The insurance broker, Publix, the insurer?
Well, to the extent that there's ambiguity, we think that should be read in favor of upholding the document. But it identifies the policies, we know the gentleman's name is Mr. Touche. At the hearing, it was argued that we know he is a broker, that he has authority to bind travelers. So that was presented to the trial court that he has authority to bind travelers. And as a practical matter in the world of insurance, these people wear different hats on different days. You may be the agent for your insured one day, agent for your insurance company the next day, and that's fairly common. And so who he was actually under these circumstances, this should be an effective document. And in the Liberty Mutual case, the question was, quote, whether a certificate of insurance labeling a third party as an additional insured standing alone entitles that third party to the same coverage as the primary insured. And the Liberty Mutual, this is 2022 11th Circuit case applying Florida law, reviewed Florida case law and found that certificates of insurance can bind the carrier to provide coverage. And the 11th Circuit made this finding based solely on the certificate at issue in that case, even though certificate there said in all caps, the certificate of insurance is not a contract of insurance and neither affirmatively nor negatively amends, extends, or alters the coverage. So there's nothing anomalous about this decision. Recently followed last year by another court, Middle District of Florida, applying Florida law, State Farm versus Taylor, which again found that there is coverage based solely, or can be coverage based solely on a certificate of insurance. I believe I'm in my rebuttal time, and I'll reserve the rest. Thank you.
Thank you.
Good morning. May it please the court, Sarah Hafiz on behalf of Appellee's Charter Oak Fire Insurance Company and Travelers Property Casualty Company of America, which I will collectively refer to as Travelers. Okay, so in this case, Publix brought a breach of contract cause of action alleging that it is entitled to additional insured coverage under Travelers policies. And Publix moved to dismiss, stating that was not true. And the trial court, looking at because this was a motion to dismiss, so the trial court looked at the four corners of the complaint and looked at the attachments to this amended complaint for Travelers policies and the certificate of insurance, and correctly determined that there was no additional insured coverage that was afforded to Publix. The issues here are very discreet and to the point. Publix is arguing 2 points here, well, 3, but 2 points under the first point, which is that it is an additional insured under Travelers policies, and it's also an additional insured under certificate of insurance. Now, when it comes to the first argument that Publix had additional insured coverage under Travelers policies, that's not true because the Travelers policies are very clear that there's no additional insured endorsement, there's no additional insured provision. So Publix is alleging that, okay, if there is no additional insured endorsement and Publix has conceded that there isn't any additional insured endorsement, it's saying that, well, it's an additional insured under the insured contract provision under the policy. Now, let's look at what's the definition of insured contract provision. Well, the insured contract provision provides coverage to the insured. It provides coverage for liability assumed by the insured under an insured contract, which in this case, Publix is saying the services agreement is the insured contract between Publix and Travelers named insured Tri-County. Now, when you look at Florida law says that insurance contracts are construed in accordance with the plain language of the policy as bargained by the parties. If the provisions are clear and unambiguous, those terms should be enforced. If they're clear and unequivocally stated, Florida courts may not write terms into the policies. Now, they're saying that Publix is an additional insured under the insured contract provision, but there's nothing that says that if there's liability for there's coverage for Tri-County's liability assumed under the insured contract, that automatically makes the indemnity, which in this case, it's Publix could potentially become, that's the highest status that Publix can get under the insured contract provision, which is the status of an indemnity, not an additional insured. The policy is not stating that. Policy.
Well, that's my question to opposing counsel. So that provision gives insurance coverage to Tri-County for that contract with Publix.
Exactly.
Not additional insured coverage directly to Publix.
Exactly.
Okay.
Exactly. So,
Is
yeah.
that consistent with the holding of Ring Power?
So that is not, well, that actually is not consistent with Ring Power, because Ring Power found that Ring Power is actually a case that, which I actually briefed about, we're saying that Ring Power respectfully got it incorrect. They're conflating the obligations under the insured contract, the indemnity and defense obligations under the insured contract with additional insured status. And so it's actually contrary, the Ring Power's holding is actually contrary to Florida established law. Florida law clearly states that you have to look at the plain language of the contract, and there's nothing in this insured contract provision that's providing additional insured status to Publix, because so there's two things going on here. If anything, Publix can get the status of indemnity, not additional insured. If you're going to be, so as an indemnity, it can, because well, this is the other thing, is that if Tri-County is found, which it has not been established, if Tri-County is found to be liable under the services agreement, then it would owe indemnity obligations to Publix. But again, that's irrelevant, because at the end of the day, what we're looking at is, does this insured contract provision provide additional insured status to Publix? And looking at the language of the policy, that is simply not true.
Were there any differences between this language in this case and the Ring Power language?
So, no, I do not believe so.
Okay.
Yeah, so, and then with Ring Power, they didn't really get into much details. It was, I don't want to say bare bones, but there wasn't many details to support its finding as to why exactly it conflated the indemnity and defense obligations under insured contract with additional insured status. But the one distinct thing that I do recall from Ring Power was that there was an independent basis at Ring Power for additional insured coverage, meaning there was an additional insured endorsement in that particular case. In this case, there's none of that.
Well, yeah, wouldn't that be the deciding factor?
Yeah, that would be the basis, but they found it that not only did Ring Power have additional insured coverage under that endorsement, but it also had additional insured coverage pursuant to that insured contract provision.
Okay,
So,
and here we don't have the endorsement.
Right. And Publix has conceded to that there is no endorsement. And also, and I cited this in pages 15 to 18 of my answer brief, that what does Florida law look at when they're trying to determine if a party is an additional insured, and they're looking at additional insured endorsements. And even when there is an additional insured endorsement, that doesn't automatically mean that a party is going to get additional insured coverage. They're looking at whether the conditions of that endorsement were actually satisfied in order to even confer additional insured coverage to the party that's seeking it. Here, we don't even get there because there's no additional insured endorsement to interpret it. And then also I cited several cases on pages 18 to 19 of my answer brief where where there's an insured contract, there's an insured contract provision, but the courts are looking at the additional insured endorsement to determine whether a party is an additional insured. And I know that counsel mentioned that these cases that I cited have to do with vicarious liability, that those cases had an additional insured endorsement about citing that in order for a party to get additional insured coverage under that endorsement, there has to be a vicarious liability claim, but that's not, I mean, the reason why I cited to those cases was not to point to that factor. I cited to those cases to show that courts are looking at additional insured endorsements to determine additional insured coverage. It doesn't matter like what was the reasoning or what was stated in those endorsements. So that was the reason why I brought up those cases. And then the other, that's one of the basis that Publix is seeking additional insured coverage under, but they're also saying that there's additional insured coverage under the certificate of insurance. And for that, I'm actually going to just go straight to the certificate of insurance here, which is page 400 in the record. Okay, so this one, the certificate of insurance, Publix is alleging that it clearly states that Publix is the additional insured under Travelers policy. That is not true because looking at the language in the certificate of liability insurance, although in the bottom it says Publix Supermarkets Inc. are included as additional insured with respect to general liability as required by written contract. On the top, which is on the top, there's a part where it says important. And this is something that I cited in my brief, which I looked at the initial brief and the reply brief, and I noticed that counsel never, well, I would guess in the reply brief because I obviously filed the answer. So I've noticed that a response was never given to this point that I made, which was the fact that it clearly states on the certificate of insurance, important certificate holder, which is Publix, is an additional insured. No, if the certificate holder is an additional insured, the policies must have additional insured provisions or be endorsed. A statement on this certificate does not confer rights to the certificate holder in lieu of such endorsements. So it's very clear, there's no ambiguity here. And of course, when you look at the policies, there's no endorsement, there's no additional insured provision. I know that counsel cited to Liberty to support their argument as to why the certificate of liability insurance should provide an independent basis for coverage, but the certificate of insurance in the Liberty case is distinct from the certificate of insurance in this case because the language that I just stated is not the certificate of insurance. The certificate of insurance in the Liberty case does not have that language. So this one, it's pretty clear that in order for Publix to be an additional insured, there must be an additional insured endorsement or provision under Travelers policies. And let's see. Oh, and then one of the other arguments that Publix raises is that, well, you know, the certificate that they have evidence that the agent that provided the certificate of insurance, it was issued by Travelers agent, but there's nothing in the record besides Publix's argument at the motion to dismiss hearing that this certificate of insurance was issued to by Travelers. And yeah, so there's nothing but in the complaint, it says that Brown & Brown, who was the agent for Tri-County, issued a certificate of insurance. So again, this is a motion to dismiss. The trial court looked at the four corners of the complaint and the attachments that are incorporated to that complaint. And it determined that sufficient ultimate facts were not pled to state a cause of action or breach of contract cause of action against travelers. And then, of course, the last point that I want to address is that they failed to preserve their the second issue that the second issue that's cited in their initial brief is that it was improper for the trial court to dismiss this case with prejudice without leave to amend. But again, they did not preserve this argument for appeal. I cited to a Florida Supreme Court case, a 4th DCA case, a 3rd DCA case, a 5th DCA case, several cases that state that if you do not request leave to amend, and if you don't object to a dismissal with prejudice and you don't seek rehearing, then you don't preserve an issue for appeal. And so, yeah, so that last issue, the issue is of amendment is not appealed. And the other thing is that in their initial brief, they went into all the factors about when you request a leave to amend, what do courts look at? They look at futility, they look at abuse of the amendment process, and they look at whether the other side is going to be prejudiced by the amendment. Well, these arguments are being brought to the appellate court's attention for the first time. They were never raised in the trial court. So it's pretty clear that this issue was not preserved for appeal, and it should not be brought to the appellate court's attention for the first time. So with that said, Your Honors, respectfully, this court should affirm the trial court's dismissal order. Publix has failed to state a breach of contract cause of action against Travelers. The complaint, Travelers' policies, and a certificate of insurance conclusively demonstrate that there was no additional insured coverage available for Publix. And again, Publix has failed to preserve for appellate review the issue of whether it was proper for the trial court to dismiss this case with prejudice without leave to amend. Thank you.
Thank you, counsel.
Oh.
Okay, you're fine. Back to rebuttal.
Couple of points I have in the time remaining. First off, with regard to, there's multiple ways that you can be insured under a policy. You can be the named insured, you can be added as an additional insured by an endorsement, which the cases they've citing. You can be covered by a certificate of insurance, which is now established by the cases we've cited, and you can be covered under insured contract provision. Here, Publix had an indemnity agreement with its vendor, and it had an agreement with its vendor that the vendor would get coverage and would provide a certificate of insurance. And then Publix got the certificate of insurance and relied upon that. That's all that normally reasonable due diligence would require and expect. Publix did everything it could to protect itself, and under the case law we have cited, that should be more than adequate, both the certificate of insurance and the insured contract provision to provide coverage. The arguments that, and again, it's you have these insurance specific policy defined terms, which include an additional insured, but that doesn't exhaust the ways that you can be covered. The certificate of insurance is a separate way.
But what about that notice language that she just read to us that's on top of the certificate of insurance? Like, what do you do about that? We would have to redact it basically to find that your argument in that point is correct.
There is no additional insured coverage in the policy, and we are not seeking additional insured coverage. We are seeking insured contract coverage and coverage under the certificate of insurance. So the arguments are about different kinds of policy provisions that extend coverage. One kind of policy provision is an additional insured endorsement. We have never relied on that. And we have spent most of our time in the arguments in the trial court and briefing in this court and today, trying to clarify that that is a different way you can be covered that we are not relying on and we are not seeking, because there's not an additional insured endorsement. There are some additional insured endorsements, but they apply to real estate managers and things like that.
I don't think we're confused on that point, if that helps you.
Well, one is a capitalized term, which can be defined, which then refers specifically to an additional insured endorsement, which, insurance policies are different. They're forms. They use the same forms over and over again. And that is one kind of their forms that they use over and over again, by which you can add someone as an additional insured. We don't rely on that. You can also be insured and be in a not capitalized additional insured to the extent that you have coverage otherwise, either like a certificate of insurance or an insured contract provision. So we do not claim an additional insured endorsement. We have never claimed that. We rely on the insured contract provision, which was what was argued to the trial court and argued on appeal, and the certificate of insurance, which was argued in the trial court and argued on appeal. So we've been making the same arguments below and on appeal, and it is easy to conflate the two. And it's easy, as our opponents have done, to accuse Ring Power of conflating the two, because they use the language additional insured, but they're not talking about an additional insured endorsement. It's just one paragraph of the Ring Power case where they say, here's what the indemnity agreement between the insured and Ring Power provided. Here's what the insured contract provision applies to. Therefore, there is coverage. And so we ask that the decision be reversed and public's allowed to pursue coverage. Thank you.
Thank you, counsel. We will be in recess.